joining us. My name is Emerald Lowe, and I'm the Membership Director for the Oceanside Chamber of Commerce. And today we're going to be hosting a webinar on the California Consumer Privacy Act. We have a partner over with Higgs Fletcher and Mack. Kevin Wheeler here is going to be sharing some details on what this is, if you should be watching out for it, and really, what the penalties are, and ways to stay, on top of the new ever-changing laws related to this. So Kevin's got a lot of great information to share today. The way it's going to work is we're going to let him kick off his presentation. And if you guys have questions, we're going to enter those in the chat function at the bottom. So that's just directly at the bottom of your screen in the middle. And oops, looks like we're jumping ahead there. So what we're going to do is have you guys just go ahead and drop your contact information in the chat function as we get started, and leave those questions in there. I'll address those as we have some natural pauses in the meeting. So without further ado, I'm going to go ahead and mute your mics, and we're going to pass the torch off to Kevin, and he's going to go ahead and jump into his presentation. So Kevin, the floor is yours.
Well, thank you very much. Appreciate that, Emerald. Good morning, everybody, and welcome to the Oceanside Chamber of Commerce webinar on the California Consumer Privacy Act. You'll have to forgive my my technological unsavviness. I just was drinking some water and pushing on the forward button, and there we were forwarding. But again, my name is Kevin Wheeler. I'm a partner at Higgs Fletcher Mack. I specialize in fintech and privacy law. I've been around San Diego for about 20 years doing this. And I know we have some lawyers on the webinar, which is great. And so whether you're a lawyer or not, feel free through the chat function to ask some questions. If you see something and you're like, ooh, I want to know a little bit more of that, Emerald will get the chats. And if we can, Emerald may just interrupt me and ask that question, or we'll wait till the end and we'll take it at the end. But I mean, there's not that many of us on this webinar, so feel free to ask questions or make some comments. I'm more than happy to make this more of a dialogue than just a lecture or webinar. So with that said, let's step right into it. Here's what we're going to talk about today. A little bit of the CCPA background and legislation, who's subject to the CCPA, something I affectionately refer to as the no, and pro aspects of the law, CCPA compliance, and how it's being enforced through both the Attorney General and civil litigation. And throughout all of this, my goal is to sort of provide best business practices. I am a business lawyer. I do pride myself on being able to provide not just a legal perspective on everything, but more of a business perspective. And so you'll see some best practices advice throughout this webinar. So let's just jump right into it. The CCPA, California Consumer Privacy Act, enacted in 2018. Interestingly, the populace didn't vote on it. It actually went through the legislative process in California, signed into law by Governor Brown. It became effective at the beginning of this year, and its enforcement date, which is when the Attorney General is allowed to start enforcing the aspects of the law, was July 1st. Interestingly, the Attorney General did not have enforcement guidelines written until just recently, just a couple of weeks ago. I think it was August 14th that the Attorney General finally came out with their enforcement guidelines. And essentially, it's any company, and I bolded and underlined it because it's kind of important, any company that does business in California may be subject to the CCPA. So if you're in Oceanside, you're definitely going to be, you may be subject to the CCPA, and we'll get into the criteria for that. But if you're in Phoenix, or maybe your headquarters are in Kansas City, anyone who does business in California may be subject to the CCPA. So the purpose of the law was to give California consumers more rights with regard to the data that's being collected about them. So under the CCPA, California consumers now get to know what data is being collected about them, whether it's being sold or shared. They get to say no to the sale of it. And if they request it, you have to give them access to the data that you're collecting on them. And they can request that you delete it. And then finally, you can't discriminate against California consumers for exercising their privacy rights. And we'll get into more detail on all of these as we go through the webinar. So what businesses are subject to the CCPA? Well, there's three general buckets. And the first one is, does your business have $25 million or more in gross revenue? And again, I'll get a little bit more detail into these a little bit later. But the first one is $25 million in gross revenue. The second one is, do you collect data on 50,000 California consumers or devices? And that's a key aspect of it. And then finally, does 50% or more of your revenue come from sharing or selling personal information? And that's a very broad definition, the idea of sharing or selling. So we'll get into those in more detail. The first one being the $25 million in gross revenue. And so you may be sitting there thinking, well, geez, we don't do 25 million in gross revenue. But if you are a company, for example, like a real estate agency that is owned by a holding company, and you have a sister company that, for example, might be like a property management company, and then who knows, you may have another sister company that has like an investment arm. And if you are all owned by the same company, like the same holding company, then you're required to aggregate your gross revenues for the purposes of the CCPA. And so if in aggregate, the holding company has $25 million in gross revenue, or its subsidiaries, then you're all subject to the mandates of the CCPA. And so it's important that if you are in a situation where you're owned by a larger entity, to check and see whether the other entities that are owned by your parent company may subject you to this $25 million in gross revenue requirement. So the next bucket of people subject, or businesses subject to the California Consumer Privacy Act, is the 50,000 consumers. And it doesn't really matter how big you are as a company, but if you collect 50,000, if you collect data on 50,000 California consumers, you're going to be subject to the CCPA. And like I said, this is a tough requirement. The 50,000 isn't just consumers, it's consumers or devices. The actual statute says consumers, households, or devices. And so let me give you an example of what it means by devices. If you have a website and you're putting information on, like a cookie on someone's computer, that's a device that qualifies under the 50,000 consumer requirement. If that same person has a cell phone and they log onto your site, that's a device for this same purpose. And so you may have one consumer but two devices. And so that, while you may think of it as only one person, that actually is two consumers under the law for the California Consumer Privacy Act. And so a lot of people have cookies on their websites. They place cookies on computers and cell phones and whomever else logs onto their website. And that would subject you to, if you have 50,000 or more of those floating out there, that would subject you to the CCPA requirements. Then the last bucket is 50% or more of your revenue coming from the sale of consumer information. And if this is the bucket that you fall under, it kind of raises some more issues. There may be other statutes that you need to take a look at. For example, you may be classified as a data broker in California, and that requires you to register with the state of California as a data broker. And so if that is the case, then I do recommend that you not only listen to the rest of this webinar, but you may have some other requirements that you're going to need to comply with in California. So here's my first best practice tip. Even so, many of you may be sitting there going like, well, good thing I don't fall into any of those three buckets. So I'm not subject to it. I can log off and not have to worry about it. Well, true, congratulations, you're not subject to the CCPA right now, but it's still a really good idea to understand the requirements of this new law and assess how you're handling your data. Here's why. Privacy laws can change really quick, especially in California. In fact, we'll get to it in just a second, but there is a ballot measure for November. It's Proposition 24. It's called the California, excuse me, it's called the California Privacy Rights Act, and it's going to change certain portions of the CCPA. It's going to expand some parts of it, and it's going to shrink other parts. And so you may be thinking now, well, I don't need to worry about the CCPA because I don't fall in any of those buckets. It's entirely possible that you will very shortly because things are changing almost like on a monthly basis. I think it was this week that the California legislature just extended a deadline for employers with regard to the consumer information they keep on their job applicants and their employees. It just goes to show that things can change quite quickly in California with regard to privacy legislation. And in addition, even if you're not subject to the CCPA, you can still be subject to California breaches. And so the CCPA is really just a great guidepost for how to ensure that you don't expose yourself to a great deal of liability for privacy law violations in California. So here's the actual proposition. I sort of took a picture of it from the website. And you can see where it says a yes vote supports this ballot initiative and expands the state's consumer privacy laws. Right now, you have a 30-day period. If the Attorney General sends you a notice of violating the CCPA, you have 30 days in which to remedy that. The CPRA will remove that 30-day time period. And the CPRA creates a privacy protection agency. And so it's going to move enforcement from the Attorney General's office, which may have other objectives, to a dedicated privacy protection agency. Then that's going to be their only job, is to go around and make sure that businesses that do business in California that are subject to the CCPA are following its mandates. And so it kind of just goes to show that even if you're not subject to it now, it's a really good idea to kind of pay attention to the privacy laws in California, because it's entirely possible that you will be in the future. So the CCPA, from a consumer's perspective, can be boiled down to something I like to call the no, no, and pro rules. So it's the right to know. Consumers have the right to know. The consumers have the right to say no, like, hey, don't sell my information. And they also have the right to protection, which would be Attorney General enforcement and potential civil litigation. So we'll get into those in a little more detail. So the right to know, right? Any organization conducting business in California is required to inform that are subject to the CCPA, required to inform its customers. What data are you collecting about them, and how are you using it? And you need to notify them. You need to let them know at the point of where you're collecting it what their rights are under the CCPA. And in California, consumers can call you up and say, I would like to know what data you're maintaining about me. And so, for example, the classic example, and honestly, Facebook has been somewhat at the cutting edge of California privacy law. On Facebook, there's a way to get Facebook to allow you to download a copy of all the data they've collected about you and shared with third parties. And that is what's required under the California Consumer Privacy Act. And this goes to show the extent by which Californians have a right to know what data you're collecting about them. Here's another good tip, right? So most companies, you got to have this language on their website to provide notice to people, right? That says something about, you can find out about the information we're collecting about you by clicking here, or call us on this phone number. And in fact, the CCPA, if you're subject to it, requires you to have 2 modes of contact for a client to request the data that you're maintaining about them. And usually it's a website and a phone number. And so if you're a business that's subject to the CCPA, you need to set up a web page that gives consumers the ability to access their data. And you don't have to do it immediately. They have to submit a request. You need to verify who they are, and then you have a certain amount of time in which to get them that data. Facebook just does it as a matter of course, but under the CCPA, you actually have some time in which to do that. Because most businesses aren't like Facebook. Like most businesses, you may store your data in several different areas. It may take you a little bit to go find all the data that you've shared with third parties for a client and collect that data. So that's the right to know, K-N-O-W. The right to say no is the consumer's right to opt out, to say, I don't want you to share the information that you've collected about me with any third parties. And the other part of the right to say no is consumers can request that you delete their personal information from your records. And when I say your records, that means the records that you have and all the service providers that you've given the consumer information to. And I put a little asterisk there. This is kind of important. And if you're a business that markets or services children, if you're less than 16 years old, if the child is less than 16 years old, you can't share that information at all. The only way you can do it is if you get an affirmative opt-in. There's some more detail to that, but just in general, that's a really important factor to know, that if you are marketing towards children and you're collecting information on individuals less than 16 years old, you have to, before you share their information or before you sell their information, you have to get their permission to do so. If it's kind of funky, if they're between 13 and 16, they can provide you that authorization. If they're less than 13, you have to get their parents' consent. More on the right to say no. There are exceptions to that. You may be thinking to yourself, like, oh my gosh, how am I going to delete all this information about these people? I have to use it for my business. Yes, and so there are exceptions to that, and it's a relatively broad exception. So, for example, if your customers are submitting information through your website in order to purchase a widget from you, and you're providing a warranty for the widget, you need to maintain their personal information in order to service that invoice, that request, and also you need to maintain that information to service the warranty claims that may come. And so even if the customer says, I want you to delete all the information that you have about me, you can maintain that information that you have a business reason to keep, which is a pretty broad exception. But for example, if you're putting cookies on a customer's phone or computer, that basically gives you like a geolocation or some other type of information about their computer, I would suspect that would not be required. You would not be required to keep that to service the customer's account. So you may need to delete that information. And so there are exceptions to it, and it kind of depends on how your business is set up. Like obviously realtors would have a different type of exception than say someone who's selling widgets. And so, you need to look sort of individually at your own business to determine what is required, what information you're required to keep for the purposes of the CCPA. Just really quickly, there are also large exceptions for entities like financial services entities that are subject to what's called the GBLA, the Graham-Leach-Lively Act. And so financial services companies like banks and your financial advisors are required to keep certain information under those statutes, and they are exempted from the CCPA for that information and only that information. And so if you think to yourself, well, I'm a financial advisor and I'm required to keep this information, so I'm not subject to the CCPA. Well, those acts don't require you to, for example, put cookies on people's computers. And so that information does not fall under the GLBA. And so you would be subject to the CCPA. Sorry, I'm a lawyer. I love acronyms. And so lots of acronyms in my world. The right to protection. So the right to protection, it starts with businesses can't discriminate against consumers for opting out of the sale of their information. And the way this usually happens is a business will essentially give incentives to people to allow them to maintain their information. For example, if you don't opt out of us maintaining your data, we'll give you a 10% off. That actually is that's a form of discrimination, and you're not allowed to do that. You're not allowed to offer differential pricing or rates unless it's directly related to the value of the data that you're keeping. So if your services are related to the information that you're collecting online, then you can discriminate you can provide essentially pricing differentials or rate differences for your services. But if someone says, hey, delete all my information, you can't just say, okay, fine, then we're never going to do business with you again, and our warranty is voided. You're not allowed to do that. The other right to protection involves the Attorney General. So the Attorney General's office is authorized to enforce the provisions of the CCPA. And if you get a letter from the CCPA, not necessary that you panic right away, but at least for right now, you have 30 days to correct any shortcomings in your business practices. And generally, the Attorney General will tell you, you're subject to the CCPA. Here's where we believe you are deficient, and then you have 30 days to correct it. If you correct it, great. Ideally, the Attorney General will go away. If you don't correct it, and the Attorney General then enforces the CCPA against you, it can get really expensive. So violations with intent, which is probably where they're going to go, is they can fine you up to $7,500 per consumer. And if you think about it, if you're subject to the CCPA, you have a 50,000 consumer requirement. 50,000 times 7,500 is big numbers, 8 digits. Accidental violations, these types of terms have yet to really be fleshed out. But for example, if the Attorney General tells you you have 30 days to correct this, you try to correct it, and you just happen to not go all the way towards getting exactly where the Attorney General wanted you to go, they can fine you up to $2,500 per customer for an accidental violation, one that they deem is not something that you intentionally chose to violate the act. But point being is that the violations of the CCPA can get very expensive. And it turns out the Attorney General actually already has issued some 30-day notices to businesses in California. So it was just August 14th that their enforcement guidelines went into effect, and they've already started sending out letters to some larger entities. And then, of course, there is civil liability for CCPA violations. The CCPA does have a private right of action. It's essentially limited to data breaches. So if you have a data breach and it is a result of your failure to follow the guidelines of the CCPA, you can be sued in a class action. And the statutory damages are up to $750 per consumer. And class actions obviously can get also very, very expensive. And so and they're not mutually exclusive. You can get both an attorney general coming after you and civil litigation at the same time. But again, this is yet to really be fleshed out. There is one case, and we'll talk about it here shortly, that relates to CCPA violations, which is kind of interesting. Let me see if it's the next slide.
Kevin, quickly before you move on to the next slide, a real quick question on a data breach. How long does a business have to notify consumers on a data breach? Is there a specific time limit per industry or something kind of across the board that businesses can follow?
Right. That's a great question. So data breach requirements, there's another statute in California that deals with data breaches. And in California, you have essentially a reasonable amount of time to notify your customers of a data breach. It's generally 30 days after you knew or should have known of the data breach. This is also an area of law that is changing. And so the question is when did you know or should have known of the data breach and the extent of it? And so oftentimes you may suspect you had a data breach, but you actually have to look into it, see what the scope is, what type of information was hacked or taken, and you have to do that investigation until you actually know the extent of the breach. And once you have that information, in California, I believe it's a 30-day notice period to provide your clients notice that their data has been exposed to the public.
Thank you for that clarification.
Sure. Okay, so this is kind of the crux of this webinar. Like, what do you need to do to comply with the CCPA? And again, even if you're not subject to it because you don't fall into one of those buckets, it's still a good idea to, I don't know how to say this the right way without sounding too lectury, but pay attention, because this could affect you eventually, and it's just a really good idea to know what your data collection practices are and what you're doing with that data. So minimally, every business in California needs to update their privacy notice to comply with the mandates of the CCPA. And you need to ensure that the consumers have a way to opt out of you sharing their information. And so that's a, do not sell my information button on your website. That's what that really is. And then you also have to have the ability to delete the consumer's information when they request it. And that may sound easy for some businesses, but other businesses, like I say, you may have given information to third parties. You may have different servers in different areas that hold consumer information. So if you're a widget manufacturer, you may have a marketing section that has consumer information in it, the manufacturing section, the sales section, an administrative section that all use different servers. And you need to be able to delete a consumer's information within a specific period of time. And sometimes that can be hard when you have a bunch of different data in different areas of your business. And so the CCPA kind of requires you to have the ability to delete that data in a prompt manner. These kind of fall under more best practices. The CCPA doesn't necessarily require them, but it's almost impossible to comply with the CCPA without doing this. So you do need to have privacy policies and procedures that are drafted to allow your business to comply with the mandates of the CCPA. So for example, you need to have the policies and procedures in place to process a customer request to delete information. And if you are sharing the information and a customer says, who are you sharing it with? You need to have the policies and procedures in place to be able to process that request. You also need to have technological solutions to, to support the do not share my information button, do not sell my information button on your website. It's not enough just to have the button there. You actually have to be able to have that technology in place that once they push that button, then it goes into your system and you're no longer allowed to share that consumer's information with any third party. You need to train your employees that are responsible for handling customers' personal information. That's a big one too. If you get a letter from the AG, or you get a class action lawsuit associated with a data breach, one of the first requests that you get in any of these types of litigation is give us your policies and procedures and tell us what you've done to train your employees to follow these procedures. And if you haven't done that, it's a really easy way for you to expose yourself to a liability for this type of violation. And here's the case I was talking about. You need to review your contracts with your service providers. So if you're subject to the CCPA, and it's not uncommon for businesses to share information with third parties in an effort to serve their clients in a more meaningful way. So you may be sharing the information with a third party in order to conduct your business. In fact, Sephora, the makeup manufacturer, they want. There's a lot of people that return and exchange, and so Sephora, among many other retailers, they were sharing their consumer information with a company called the Retail Equation. And the Retail Equation would take all this data and create risk profiles of customers. And they would then give that information back to these retailers so that these retailers would be able to risk profile these customers and decide whether they want to do business with them or not. Well, what Sephora wasn't doing is notifying their customers that they were sharing the personally identifiable information with this third party for the purpose of doing these risk profiles. And so I think it was August, beginning of August, this class action came out, and it's not just Sephora, I think it's several other retailers. But it just goes to, and so we don't really know yet what sort of processes and procedures the Retail Equation had in place in order to protect this consumer information. I think that's at the crux of this lawsuit. So Sephora may have been sharing information with one of its service providers, and its service provider may not have had the appropriate policies and procedures in place to protect this information. And Sephora may be subject to liability for sharing information with a third party that doesn't have the appropriate policies and procedures. So really important that you update your contracts, or at least review them with those entities that you're sharing information with, to ensure that they are complying with the CCPA and they have the right policies and procedures in place to ensure that the consumer information is being protected. So this is another best practice slide. And it essentially just says, know what your data collection practices are and how it is that you are storing all this information. So what information are you collecting? Where are you storing it? And are you sharing it? It sounds so simple, but oftentimes not a lot of companies know exactly the answer to those three questions. And you should start with doing a data assessment, that answers these three questions. And once you know that, you'll have a better idea of what you'll need to do to put the appropriate policies and procedures and technical safeguards in place. So for example, technical safeguards. How are you managing your data storage requirements? What sort of network security do you have in place? And this is a big one, email security, right? Vast majority of all data hacks start with an email, right? With the classic, I just got one on my phone this morning from PayPal, or at least it alleged to be from PayPal, that said, your PayPal account is overdrawn, please click here. And of course, if you go to who the sender is, it's like a random list of letters and numbers @ sign, and then a random list of letters and numbers.com. Clearly not from PayPal, but you obviously don't click on the attachments or the links in those emails, because that's where most data hacks start. And are you providing your employees training as it relates to those types of emails? I used to work at Ally Bank in their financial services division. I was the general counsel for Ally Bank's financial services. And Ally had a great email security system. And then of course they would send out mock emails. And if you clicked on one of them, that you would get an email from the IT group saying, shame on you. And if you did that 3 times in a 12-month period of time, you'd get written up for it, and it may affect your bonus. And so everybody was like super paranoid about clicking on the wrong email. And so that kind of technical safeguard needs to be in place. Those types of policies and procedures need to be implemented at your business, because if you do have a data breach, one of the best defenses to any sort of litigation or liability, whether it's from the Attorney General or in a civil action, is we have the appropriate policies and procedures in place. And look, data hacks are gonna occur. They're basically a fact of life in our modern society. And it's not necessarily whether the data hack occurred, it's what did you do prior to the data hack with regard to your policies and procedures? What did you do in connection with those policies and procedures when they occurred? And what did you do afterward to fix those parts of your network or data storage requirements to ensure it never happens again? And so if you have that kind of stuff in place, you will be long down the road to avoiding massive liability under statutes like the CCPA or other data privacy or privacy laws. So here are the 3 big issues. Are you subject to the CCPA? And it's a little bit of my admonition, like, even if you're not subject to the CCPA, be aware of it, because you may in the future, you may grow. I forgot to talk about that. You may grow into being subject to the CCPA, and it's entirely possible over the next year to 2 years that the requirements of the CCPA can change. We have a November ballot measure that's going to potentially do that this November. Do you honor the no, and pro principles? That's the meat of the CCPA, letting your California consumers know their rights, give them the opportunity to say no, don't sell my information, and then finally give them the appropriate protections under the law. And then finally, do you have the policies and procedures and technological safeguards in place to ensure that if indeed there is a violation of the CCPA, or there's a data breach, you have the ability to respond to either requests to delete information or requests to opt out of selling the information, or address the downstream effects of a data breach. And so that is my webinar on the California Consumer Privacy Act, and more than happy to answer any questions, or really if you have any comments, let's flesh them out. This is a really good time to do it.
Well, first off, thank you so much for all of this information, Kevin. This presentation has, a lot of detailed information, so we're going to share this with you guys after the fact. But we do have a quick question in our chat box. So from Stacy, Hi, any information on security policy from my credit card processor, bit of an overwhelming document. Any suggestions about filling that out? And does this apply to the CCPA policy? So this may or may not be something you might have to answer offline, Kevin, but I'll hand the torch off to you for that one.
Sure. Yeah. So these credit card processors, honestly, they're a little paranoid about the CCPA because obviously they're going to be subject to it because they do collect a lot of information. Credit card processors collect a lot of information about you, not just your credit card information, you know, and obviously there are federal and state statutes that require them to collect certain information about you, but they also collect a ton of other information. For example, your purchase history and things like that. And so those documents are overwhelming. They're huge. They're written by, you know, lawyers that are looking into the tiniest little ways that their clients can be, you know, exposed to liability. And so any suggestions about filling it out? Well, yeah, I mean, as a California consumer, if you're concerned about your data being out on the information superhighway, go ahead and opt out. Opt out of people sharing your information. It doesn't necessarily apply to the CCPA policy in total, because like I said, they have certain requirements to maintain information about their customers. But you know, those cookies that they're putting on your computer, your purchase history, those do not fall under most of the federal and state regulations, and that would fall under CCPA because that's really what they want to share, right? And so if you are concerned about it, opt out, you know, exercise your right to do so.
Thank you for that, Kevin. And that's actually a great segue into a question I have myself. Working with a large number of restaurants, we're hearing more of them collecting personal information in respect to the health order. So they're collecting information from parties. So the information pertains contact information. Is that, does that fall under CCPA?
Wow, that's a great question. To tell you the truth, Emerald, I don't know how the health orders, how they integrate with the CCPA. That is a great question.
It's a new development, so that's totally fair. And we'd love to work with you more off topic about that, if that's okay.
Yeah, not a problem at all. I mean, there, you know, in light of our sort of more recent, you know, coronavirus pandemic environment, there's certainly a lot of restaurants that are collecting information on people. For example, what it is you order, right? We ordered from Rubio's recently. We have the Rubio's app, and Rubio's knows obviously what we're eating, and they can suggest certain items, or they can say, do you want to order what you last ordered? That would be data that falls under the CCPA. That would be, you know, it's a very broad definition of consumer information under the CCPA. It's even broader than most privacy statutes. Privacy statutes are more concerned with what's defined as personally identifiable information. And usually that is any information that would lead you to an account. It's a very general way of using it, like a social security number or an email address and your mailing address. That is personally identifiable information. But the CCPA its definition of consumer information is broader than that. And that would include things like Rubio's knowledge of my mahi-mahi burrito habit. So I could, under the CCPA, I could request that they delete that information, not share that information with any third parties.
Do we have any other specific industry questions while we have Kevin on the call? This is great information here. I'm trying to make sure we have all of your mics unmuted. Matt, and one quick one I have just in working with other industries, Kevin, would be, you know, for people like Erica that are working with businesses kind of taking things off their plate like marketing, and they may fall into, you know, liability with the CCPAs. They're collecting information out there, building email lists and things like that. Do you recommend that they come up with some sort of contract together before they start doing business, that person that's doing the outreach is in compliance with the CCPA? I hope that makes sense.
Absolutely. That's part of that, making sure that the third parties that you're getting information from or that you're sharing with have the appropriate safeguards in place. And if you are a marketing agency, and for example, if you're putting together a list of emails, and you may get a list of 10,000 emails from one entity and 25,000 emails from another, and 20,000 emails from a third entity, you have just now collected data on over 50,000 California consumers. That subjects you to the California Consumer Privacy Act. And so if you're just an aggregator, data aggregator, you could be subject to these laws, and you would have to be able to notify the consumers, I have your data, you have the right to ask me not to share it, and you have the right to ask me to delete it.
Yeah, I think that gives a lot of us some things to think about as we're working with, business to business, not necessarily business to consumer. So.
Right. I actually do have some clients that are real estate agents, and they have these enormous lists of California residents, mostly Southern California, because they're here in San Diego, and they have more than 50,000 people on their mailing lists. They're subject to the California Consumer Privacy Act as a result of that.
Well, any other questions? While we have Kevin on the call, we can go ahead and unmute mics. If you guys are comfortable, you can go ahead and just jump right in with whatever questions you have for your specific industry.
I will say I'm in the restaurant industry. I'm so not worried about the new policy because having worked don't go to a Michelin starred restaurant if you don't want everything about you known, for example, because before pre-shift, we would sit down and everybody would have Googled the night's incoming guests so that we knew who they were and what they did. So for me, getting a phone number for dine-in is just a precaution. I'm not worried about that. But I do have my website that every time somebody does order online, we have both phone number and email, but I am in no way, shape, or form going to meet that 50,000 threshold. And I'm also not selling my information. So if I'm parsing what you're saying, it really won't matter that that information is coming into my hands as long as I'm not distributing it, selling it, I'm keeping it safe from my staff, and I'm below that 50,000 threshold. That
is correct, Stacy. If you're not selling the information, you don't really have to worry about it too much. But remember, as a restaurant, as you grow and as time goes on, you may only get a couple thousand this year and a couple thousand next year, but over time you may eventually end up with more than 50,000 customers. And at some point, if you ever do decide, if someone comes to you and says, hey, we understand you have all of this contact information for people who have made reservations at your restaurant, we would like to buy that information from you, which is not, and it's the lure of easy money. It's got a very strong appeal. It's a great line from Glenn Fry. Like if someone like Open Door comes to you and says, we'd like to buy that information from you, you better be careful because you might be subject to the California Consumer Privacy Act. But from what you said right now, it doesn't sound like you are subject to it. And
actually, the last bit is that information, and this is what I'll have to reach back to, is collected possibly from my website builder. My website Wix is the one that actually does collect my orders and then sends them to me. So I should be investigating with them how they're complying to the CCPA. Is that correct?
That is absolutely correct. That's a great point too. Yep.
Okay. Thank you for your time.
Yeah, sure. And feel free, everybody. My contact information is here on this last slide. Gratuitous marketing point for Higgs Fletcher and Mack. I'm a San Diegan, been in San Diego all my life, so more than happy to talk to people about their businesses. If you want to just flesh out an idea with me, give me a call. I'm more than happy to talk about this kind of stuff. I'm a little bit of a privacy law geek, and so love talking about how it applies to various businesses. And if I can help out without being, without having to, sign you up as a client of the firm, I'll do so. And if we have to sign you up as a client of the firm, we'll try to do it in the most efficient and effective way, so I'm not bankrupting you, because I know legal fees can get expensive really fast. But feel free to reach out, give me a call. More than happy to talk about it.
Thank you for that, Kevin. And, of course, the goal is always to reach out to you before those legal fees rack up. So I hope that you guys, can connect with Kevin after. We are going to go ahead and share this presentation for everyone that has registered online, and this will be uploaded to our YouTube channel as well. So you guys will have a copy of the chat, the questions that were answered in there too. But thank you all so much for your time, and you can stay tuned for future events on the Chamber website. Have a great rest of your day, guys.
Thank you, everyone.